How are things?
Things are good. I'm back.
Yeah, it's very good. I know because your little friend who was very quiet last week is just sitting here, still not saying much, I've got to tell you.
No, it's good to be back, and thanks for the kind messages from a couple of people checking in. So yeah, good to be here.
Yeah, now look, how's lockdown going with 3 kids?
I think we can move on to that next question. How about you?
Look, a lot of cooking, occasional red wine. Yeah, life's good, but it's much easier for me than it is for you and a number of our other staff with kids at home. I know that. But we'll move on. The CEO information that you've got. You want to talk about that very briefly and tell us what's going to happen?
Yes. So the survey, which is the report, I've got the finalised version of that. So we're going to be sending that out to everyone in our community here for the Friday Workplace Briefing, and also to a group of CEOs who we sent that out to take part. So look, some interesting findings in there. I think last week you covered off in terms of some key points. But look, feel free to document that. It is a pulse survey, so it'll be interesting to see what feedback we get from you, and certainly feel free to share it with your executive group. And if they've got some insight, very happy to hear from them too.
I think Karen and I are pretty interested in going to the HR, OHS and workers' comp people who are working there with a slightly different survey, just looking about what the impact of change is, how that impacts your role, and what are the things that would help you manage that better. Because the CEO, the information in the CEO stuff has just been fantastic, hasn't it? I mean, it's quite insightful. For us, it's been really helpful. Both of us leaders in our own group. Reading it reminds us what good leadership looks like as well.
Yep.
So we think if we can provide you with this information, it's something very useful for you to use. We really appreciate our community being so generous with their time. Actually, it's been lovely. The response rate was much higher than we ever expected, and we did ask quite a lot. So that's really impressive. Anyway, look, that's enough of the hellos, and I'll just move this character away now because you're back, Karen, and thank God you're back, because it's pretty hard doing this on your own. I thought I'd start off with the first case of Lucas and compaction soil. Interesting case that Matt summarised and will subsequently become an article that he sticks online, about a woman who was employed, was given an extended probation period. On any measure of her employment behaviour is pretty poor throughout it. Her employment was eventually terminated after attending late at work, and the decision makers, the owners of the business, were not aware that she'd actually rung in saying she was late, nor were they aware that she'd had some sick leave the day before. She brought an adverse action claim because she was excluded from bringing an adverse action claim, bringing an unfair dismissal claim by the nature of being within the qualifying period, potentially a jurisdictional issue. So all the failures in procedural fairness mean nothing. That's the first thing I want to say when you bring an adverse action claim. But what the court clearly found is the decision makers had no knowledge of the temporary absence issue, and therefore it was a lawful termination in respect of adverse action. Now, it's not an exciting case, all right? I don't want you to go out and read it. What I want you to realise is Karen and I have been talking for a long time about quarantining the decision maker. In other words, providing the decision maker with the evidence which is germane to the issue at hand, and not putting gossip about them being unhealthy, about their mental health, not doing all that stuff, just dealing with the issues at hand when a person does a termination, and just one decision maker, because it is the subjective intention of the decision maker that matters in adverse action. And here's a case where there is a presumption that sits within legislation about temporary absence. You cannot terminate for that reason. And they said, well, that wasn't the reason. The reason they terminated is because she was late to work, and they didn't know about the temporary absence. That's a very powerful decision. It's one that will be sustained on appeal if any argument were to come. So not a lot I can ask you about that, Karen, other than when you go towards the dismissal of someone, please get your ducks in a row. That's the key issue, isn't it?
Absolutely. And the issue that they've highlighted there as being the reason for termination was her attendance, when there were many other issues relating to her performance as well. So the thing is that what is the issue, understanding what that is and managing that appropriately. I take that as a key part too.
Yeah. That starts from the day you decide to start managing someone. You identify who the decision maker is and you quarantine them. Keep all the gossip away from them. Keep all the dirty stuff away. Deal with the factual issues around the person's performance. Next case is a case Nina summarised, and again, you'll see an article later in the week from Nina on WorkSafe New Zealand and Pakiri. Bakeri is a logging business that had a principal contractor called Earnslaw. They had a skyline where logs came down the hill on these skylines. An audit had been undertaken, independent audit, that showed that there needed to be a 45-metre exclusion zone around the skyline. And a man was standing at 20 metres, got hit and killed. Again, this case is not magical. It's a factual case. But I guess for Karen and I, and we were talking about this just prior to coming on, how often do we have audit reports that don't actually characterise risk in a way that the executive or officers of the organisation could know? So here is clearly a fatality risk. So it is the highest level of risk. It should have been dealt with immediately. It cost no capital to do it. So it was a free safety measure, and yet it wasn't done, okay? The officers are on notice because of the nature of the audit. So the audit would go into the board report. My issue about this case is not so much that you've got to be dumb when you get an audit report that says it's a fatality risk and you do nothing about it and it's not going to cost you any money. That's about as dumb as you can get. And that's why they were prosecuted, because it was a lay down misere. They couldn't avoid prosecution. But our idea is we try not to kill and hurt people. And there are a whole lot of measures that we utilise which prevent that. But unfortunately, our executive and governance groups look only towards lost time injuries a lot of the time, which are completely meaningless. They don't provide you any real evidence at all around the inherent risk that sits beneath it. But you do have near misses. You do have hazard identification. You have had risk analysis. You do have walkthroughs and things that capture risk. And what I don't understand is how often that level of risk and measurement of risk. Remember, reasonable practicability, identify the hazard, determine the level of risk, institute a control using the resource of the organisation. At an officer level, if you've got a fatality risk which is unchecked, you've got to know about it. You've got to know about that risk, because that's a go to jail risk. So, Karen, over to you on this, but this case concerns me, A, because you don't comply with an audit risk, but it really brings home this whole issue that you and I constantly have, that people look at lag indicators like lost time injuries and don't reflect and learn from the information that's coming through every day talking about risk.
Yeah. So and I think there has been a shift, and there's some maturity around the safety journey broadly across organisations. So I'm quite encouraged by that part of it. The thing here is that you need to let's not wait for an incident to occur to manage it. Near misses, if they're not being captured now and prioritised now, and hazards, if they're not being treated at the same level, they're lost opportunities to prevent an incident or from occurring. So, and even with that, when you're classifying near misses and hazards as well, it's not about what actually happened. We're talking about, you've got to risk rate it on the potential, because you don't know when something might happen. So that's all that, if that's not being captured at the moment, and part of it could be that perhaps organisationally we don't make it easy for people to firstly understand what a hazard and near miss is, and secondly, how do I go about reporting that, and what's the mechanism for managing that? That's a different kind of conversation for a different day. But how is it that the executive group or officers able to see and manage and govern the business if they don't have visibility of that as well? So it's tiered, Andrew, but certainly, yeah, there's a lot to talk on this one. But I think you've got my key point here would be near misses and hazards. Treat them the same way as you treat an LTI, MTI, because those, it could have just like that. It was just lucky or through something else that didn't eventuate. So.
And I guess the other thing is to make reporting easy.
Absolutely.
Let's not have death by paperwork. The most important thing is let's collect the information, then against the 12 to 18 system measures that you've got in the organisation. So in this case, traffic, if it's traffic management, whatever it is, that information should be live information that's coming through to a board when it sits down and it can see that instead of being green and traffic management, it's presently red, and it goes there, the gap, and underneath it says, look, we've had 2 near misses and we haven't fixed these problems and we must fix them and we need these resources. Anyway, talk about that another time. I just really want to focus. Paperwork in safety is a killer. Quick, simple, easy means people will report stuff. The guts of what we're talking about today is around recruiting people and what you do with a candidate in relation to their capacity to actually do the work, okay? we don't talk about this a lot, and we employ a lot of people who actually can't do their job. And we find that out several years later, okay? And then we can't do anything about it because we've condoned the person's incapacity for a long period of time. So Karen and I thought we'd have a look at the case law and start a discussion. We're going to start a discussion this week on health. We're going to move through to next week on things like education, skills, experience, because remember, when you hire someone, you hire people because of their education, skills and experience. And if they lie about those, you've got a real problem, haven't you? Okay. But one of the difficulties is we hire people regularly who actually can't do the job. Or if they can do the job, it is dangerous to them or others when they do the job.
Or it could be that they thought they're taking on a job that isn't actually the job. So that goes back to the PDP. But anyway.
Yeah, and we'll swing back to the PDPs because I know you've got a bit of an axe to grind on that. We'll come back. But I guess the thing is, when we go back to the old airline pilots case, that made it very clear that in employment law terms, it is a proper thing for an employer to do prior to recruiting someone to satisfy themselves that the person is capable of doing the job. It's not a safety issue at this stage, but they are capable of doing the job, and discrimination law sits on the end of that and says, and if they're not, what would be the reasonable adjustments that need to be made so the person can? You can't discriminate on the basis that a person has some incapacity if there's a reasonable adjustment that can be made. Very basic law. I'm sorry, I'm probably boring with that. Safety law regularly said, well, even if the person can do it, if it creates a risk to their health or the risk to others, then once again, you can say no. And in the recent COVID thing, a person coming with COVID, you'd be able to say, no, look, I'm afraid not until you've had 3 negative tests can we actually engage you. Why? Because you're a risk to other people. Okay. So they're the things which are the precursor, but how do I do that? And this comes to the 4 key steps of what I do when I'm about to recruit someone. The first thing is, Karen, position description. What's got to be in there?
Well, position descriptions, the core responsibilities and tasks we need to outline in terms of the qualifications and any relevant experience, being quite specific about that, being clear about what is compulsory versus what would be ideal. And in terms of functionally as well, it should include in there in terms of any physical, if there's a physical component to the job, that should be outlined. But also mention in terms of other factors, like in terms of the environment or the type of work they're involved in terms of the setting. So for example, fast-paced, high-pressure environment, being able to build relationships really quickly, just being able to change and adapt really quickly. Those things are relevant to the nature of the work or the job. They should be in there.
Yeah, so let's be really clear to everyone. Don't avoid psychosocial risk. Actually take some time to contemplate what are the pressures that sit inside a job and make sure that's in the position description, because step 1 is get the position description right. Step 2 is say to the person in very clear language, you must be able to do this job in every part. And if you lie or omit to tell us something about your capacity to do this job as it is described, we can terminate your employment. And in Victoria and Queensland, we can also reject any workers' comp claim because we will not be on liability because you failed to disclose it. And there are declaration forms that we use that Kim's got here for Queensland and for Victoria that you can use. But my point about this is very clear. The person must have it brought home to them that when they say they can do it, they can do it. When they say they have experience, skills, when they say about their health status, it is true. And if they don't, there's trouble. Now, the way to do that is to put in a statutory declaration, because then it is a crime to lie about it. And there should be, next to the person who's talking to the person, a very clear script which brings home to that person why it is important that they tell the truth, not only about a current injury, but a historical injury or illness that may in any way impact what they're doing. Okay, so that's stage 2. You've got the declaration process. Okay, stage 3 is you make sure that you say to them unequivocally that they are not obliged to tell us anything. And when you're writing to the doctor or the health professional, please do not tell us anything about this person's health condition, which does not relate to this job. Okay, because that's clearly a breach of privacy legislation. Okay, and then were you to make a decision based on that information. So let's use a really simple example. Karen invites me to apply for a job. I suffer from depression. I take some medication, and I'm very controlled, and the nature of my job is not a stressful job, and the job you're asking me to do is not stressful. My doctor, because Karen sends a letter saying, tell us everything about the person and or medications, tells Karen that I've got depression and that I'm on medications. And Karen, as a result of that, makes a decision not to employ me, because if the doctor tells me that, I've got to assume. I'll come back to you in a second, Leonie. Have you got to assume, well, maybe Andrew will break down, he won't be able to do this. Well, that's discrimination. You can hear the gong go bang. That's a breach of privacy law. Bang. That's adverse action. Bang. Okay? That's criminal. It's wrong. Okay? So step 3 is make sure you tell people not to disclose, and you make sure you're treating health professionals and they're treating health professionals. Don't tell you stuff that's irrelevant. And 4, it must be in your contract. Okay? It must say in the contract when the person goes to sign it that they have honestly filled these out, and if they don't, it will lead to immediate termination of their employment. Okay, they're really important steps. You don't do those things, and you don't do stat decs. Alison Toll tells you, for a bloke who failed to disclose an injury which was 30 years ago to his back, but was still symptomatic at the time which he employed and became symptomatic 3 years later. They just said, we never brought it home to him.
Yeah, just a cautionary point on this, Andrew, in terms of making the offer of employment as well, because sometimes often there are operational pressures being applied to, let's get this person in quickly and secure them for this job. And sometimes it's really easy to forget all that and let that happen after, more so as a formality. That essentially, undoes the whole process, doesn't it?
Yeah. Look, I think so often, in fact, in quite senior jobs, it's done through relationships. And there's 2 vices that sneak into this. One is, if you look at some of my crew, they've come from 2 law firms. So they've come from my last law firm, and they've come from one of the other solicitors' last law firm. So there's a lot of us from 2 law firms here, okay? Did we go through this every time? To be honest with you, no, we didn't. Have we had problems because we did that? Absolutely, we've had problems because we did it. And that's people who are meant to know what they're doing. So that's the first problem. The second one is I say to Karen, and I've known Karen now for 18 years, Karen?
Mm-hmm.
Yeah, 18 years. Yeah, it's hard to believe I knew Karen when she was 3. And I just say to Karen, look, Karen, come and work for us. This is what I'm going to pay you. The job's this. And Karen goes, yes. And then I send her out a contract and she signs the contract. Well, the contract has no effect at all. Just be really clear about that. Because I've already done the deal with Karen. And therefore, the contract becomes reasonable terms that would be adjudged by a court. I mean, it's farcical, isn't it? Because I don't actually know what those reasonable terms are. But any notice provision is completely overruled by reasonable notice. So in Karen, who's a highly paid employee of high skill, her notice period, were it not for the contract, would be 6 months. Not a great place to end up, is it? Now, to Leonie's question about who's authorised to sign the stat dec, okay, just Google it for a start. But as Leonie has said, always make sure that the person who signs it is an authorised person under the legislation, otherwise the stat dec's meaningless. Mind you, if they give you a stat dec, it is an act of dishonesty to have it signed by somebody else. And there is a series of cases on dishonesty which say that's serious misconduct. But it's a great question, Leonie. Okay, so that's where we are. So this week we've talked about it. Just remember, at any stage of a person, if you're concerned about their physical health, at common law, you're entitled to direct a person to undertake a medical examination. The case for that is column 1, GO and GEO. It should be in your contract of employment. Okay, we don't want to be having fights about the capacity to direct someone. Okay, we don't want to be having that fight, because particularly in psychological problems, the person is already incredibly vulnerable, probably isn't receiving help. If it's a guy, doesn't want to get help and doesn't want to acknowledge the issue they got. And you have a fight because they're already distressed and damaged. Bad place to be. Whereas if we just go to the contract and say, look, we do have these concerns, they're reasonable concerns, it's a direction. That becomes a lawful and reasonable direction as a matter of law, both at common law and under the Fair Work Act. Okay? Failure to comply with a lawful and reasonable direction is serious misconduct. Margaret, it's good to have it in a policy. A policy can equal lawful and reasonable directions, but a contract's so much better place to have it, isn't it? Because that's actually agreed to by the person, whereas a policy is imposed upon a person, and that's not as powerful. So my suggestion is, as part of this process that I've talked about, recruitment process, He goes into what is a medical history. It goes in there saying we're entitled to seek your past medical history where it relates to the job. You consent to the provision of that information from your treating medical practitioners, and should the organisation at any time have reasonable concerns as to your health or fitness at work, it is able to direct you to undertake a health-based investigation that pertains to their concerns. It's got to be there. But policy is a good start. It's better than nothing. All right, well, we're there. We're right up to the case study. So, Soph, hit the case study. Okay, Daniel applied for a job as an operation manager at Reckless Maintenance, a national maintenance business located in New South Wales. Reckless in-house engineering maintenance for small family-based manufacturers throughout Australia. It used MEX maintenance software to manage the maintenance regime. Daniel said he was skilled and experienced in MEX. The position description made it clear he would need to climb some stairs and ladders to review major maintenance work. Daniel filled out his pre-med assessment form. It asked if he had any injury, illness or condition that would prevent him from safely undertaking the inherent requirements of the job. He said no. He'd been working in a similar role with a major manufacturer for many years. He said the same to the examining doctor, and that's the doctor who was checking him out for his pre-med. Daniel had significant osteoarthritis in his left knee. It would swell, hurt and become symptomatic if he climbed more than a few flights of stairs in one go, which is taken directly from my medical history, I might say. Within 3 months, he took personal leave for pain in his knee. The family business were old school. Everything involved stairs and platforms. Great words just used, Andrew? Okay. Okay, next, let's go here. Reckless was advised by a past colleague of Daniel that he had a significant knee injuries after playing AFL football. The bosses sat him down for disciplinary discussion. 2 issues were on the table. He knew nothing about MEX and relied on his team, and he failed to disclose his past knee issues. Daniel denied the past knee problems should have been problematic, but for the unsafe workplace. He said they had no right to speak about his personal health with another person without his consent. Daniel also said he understood MEX, but because of his seniority, he never entered anything in it, and said they have gone behind his back and damaged his reputation internally. Reckless decided to summarily terminate his employment as they formed the view that he lied to them before he's employed at the meeting. Okay, let's go to see the poll. Poll's hard today, so go for it, Soph. Roll out the poll. We'll give everyone a little bit of time here, Karen.
Mm-hmm.
I'm manipulating things around the screen on mine. I've actually got this incredibly good helper who's been helping me the whole time. Can't see him behind the scenes.
Mm-hmm.
Well experienced. By the way, thank you everyone for turning up. We've got a huge turn up today, which is just wonderful. I know lockdowns, if we're your entertainment for lockdown, that's very sad. But it's just lovely to have you along, and it's such a surprise to see so many, well over 100 people turning up to have a chat to us today. So that's great.
That's great. Now I know we're moving along today, Andrew. So Sophie, if we don't get a chance to load up that slide that I've got on inherent requirements, that's okay, because we'll send it out to everyone anyway.
It's my fault. I forgot all about it because we got talking. Risk for you,
right.
A significant risk for you and I. I think we'll give it 10 more seconds. We'll knock this down in 10 more seconds, Karen.
Okay.
You're going to take control, aren't you?
Sure, I can do that.
Good.
Okay. Let's see. 5, 4, 3, 2, 1. Thank you, everyone. That's most people casting their vote. And let's see. Here we go.
Wonderful. Okay, look, what I want to go through now. Oh shit! I've done the wrong thing. That koala got carried away and put it across my whole screen. Could Reckless have required Daniel to go for a medical examination? Not only could they, under Columbine and GEO, and also Grant and BHP in a number of other cases, they should have. That is actually, they should have, because they had no evidence, no proper evidence upon which to rely. And if they were forming a view he wasn't fit for work beforehand, they have to form that on the balance of probabilities. It's very serious under Briginshaw to form that view. Therefore, they had to do more than rely on just gossip. and observation. Okay? So whatever they did was flawed from the very beginning by relying on evidence of an observational knowledge. Yes, he'd put in a sick certificate, but they had no knowledge as to how he hurt his knee. They, yes, he hurt it on stairs, but did he hurt it playing footy at the weekend? It got worse because he did stairs. They don't know. Does Daniel have a valid workers' compensation claim? Boy, does Daniel have a valid workers' compensation claim. And you know how bad this one is? It is for the entire period. He doesn't have to work again. And if he doesn't work again, your premium is incredibly exposed. In Victoria, 3 years, everywhere else 4 to 5 years. You're going to max this claim out because you terminated him before you found out what his condition was. And he definitely has a claim because you even agree that he did it climbing stairs. Now, the issue is, did you have a relevant declaration that he signed beforehand? Well, certainly wasn't brought home to him, was it? What would happen if he didn't get it right? But what Karen raised is the big issue. Where was it in the PD that said, actually, it's not like where you normally work? These are small family business where you clamber up stuff all the time. It's very different. You're constantly doing it. So it failed to disclose the nature of the risk. So therefore, any declaration he made in any event would have been honest. So you can't terminate him for that reason, and he definitely wouldn't be able to reject a workers' comp claim. Now, there are cases, WMZC and Comcare is a case that shows where it's done correctly, and it is rejected. This is not such a case. Daniel's annual salary is $140,000. So he's under whatever the limit is now, which I think is $156,000. I can't remember. I know Nina will be just laughing at me now. Nina, please don't come on air. But definitely within the unfair dismissal regime. Would he have a strong unfair dismissal claim? What do you reckon, guys? Let's see what you think. We think people aren't so sure as to whether you'd have a strong unfair dismissal claim. The answer is, where was the procedural fairness? Okay, remember the first part of procedural fairness is you have to have evidence that you can properly rely on to put to someone. And there's Nina. She's come in, 158,500. God damn it, she's here. Thank you, Nina. So he's well within it. So the answer is the entire procedural fairness part has failed because they failed to have the proper evidence before them. Now, should they have investigated the claims that were made? Absolutely. If they feel so strongly about it, if they feel he's lied about his past work history in MEX, if they feel that he's lied about it, there has to be some investigation. There has to be objective evidence. There's no attempt to deal with MEX or what his knowledge was. He's not asked that. He's just terminated. Okay? So procedurally, it must fail. So is there a valid reason? Potentially a valid reason. You may get over the line. Was it harsh? Definitely. Is it unjust? Definitely. Was it reasonable? No. So it fails on all three of those tests. So definitely unfair dismissal. The problems with Daniel started when he complained that the work environment at several of the clients were unsafe because of excessive climbing. It was then the bosses started making inquiries about his health. Could this be adverse action? He's raised a complaint based on safety, okay? That's a workplace right under adverse action. So he's put the line down and they have since prosecuted him around his failure to be able to do work. His failure to be able to do the work, which has been unverified, without any proper testing, without any investigation process, means this is squarely an adverse action claim. So interesting set of facts today. I'm sorry this was a hard set of facts because we really wanted to agitate these issues with you, and we're happy to go in and dig a bit deeper if that's what you'd like next week. Now, there was a question that just came out very quickly, and it came out, can the requirements be part of an enterprise agreement, medical assessment? Yes, they can, Karen. There's no doubt about it. Okay, I still like things to be in contracts because it is the individual agreeing at the time they enter into it, but an enterprise agreement is terrific. It's a statutory instrument. It's great. So what I want you to do from today is to go and have a look at your own system and say, when we go to recruit people, do we have those 4 elements in there? Love to get your feedback about that. I'd love to get your questions, not now because we're running out of time, but I'd love to get your questions back to us because we'll address more of it next week. But next week, we're going to look at relevant skills and experience. And we've seen principals of schools who aren't teachers. We've seen all sorts of things. So sometimes it's very obvious that you can sack a person, but we should know when someone misleads us, what we can do, and we should have some system around satisfying when people say they have the skills and experience they do. That's for next week. Karen, just lovely to see you. So much better than the koala, I can't tell you.
Well, soon we'll be back in the same room, Andrew, so that'll
even be better. All right, guys, see you later. Thanks for this.
Thanks, everyone.
Bye-bye.
Bye.